Welcome, I'm attorney Tom Howard. Today we're going to be discussing the largest piece of collateral that most people will ever own, their residence. And the question that we are answering today is, can I get out of my residential real estate contract in Illinois? The answer to that is not binary. It's not just a yes or no. It is very often in law. It depends. Of course, you should talk to a lawyer before you sign the real estate contract, but from the search term that we have and the question we're answering, we are kind of assuming that you've already signed the residential real estate contract and now you're getting cold feet. You're trying to figure out if you can still get out of it. The first thing you're going to want to look at are all the deadlines that are going on in the contract. Why? Because very often time is of the essence in these types of things, and you are looking for an exit based upon some type of default, or sometimes you have the right to exit a real estate contract, especially when it's a residential real estate contract. Somewhat of a cooling off period, they call it. And if you review the par one, it's actually toward the end of the contract. It's all in bold. So if you're looking for a way to get out and you've just recently signed this contract, maybe there is an attorney modification clause. The attorney modification clause is what it's commonly known as very often, and it provides both the buyer and the seller to take the contract and review it with an attorney within a few days. In this contract, it's 5, it may be 5, it may be 10. Realtors are going to want it to be a shorter period of time because they want the contracts to be enforceable, because they want to close those contracts because then they get paid. Review your residential real estate contract for some type of attorney's modification clause and see if you're still within that time window. That might provide you a way to get out of the contract. Now, let's assume that you've missed that deadline, you've blown it. We're going to be moving on to the next element. The next thing you're really going to be wanting to look for is some type of default. A default is when you have not, or a party has not done something they were legally obligated to do by the contract. This basically means you have to do something, there is a price very often that you will pay to get that done, and then you must do it. Failure to perform in any term of a contract can often constitute a default. Most contracts, the good ones, are going to define default. Please review your residential real estate sales contract to find the default provision. Contracts are very frequently organized as if they are outlines. They typically have subheadings, headings, numbers, letters, and when you are referencing a specific default, often you say, pursuant to subsection B of section 5, providing that, and then whatever right alleging has either been breached or the other party has breached. You have some type of remedy that then can be triggered as a result of an action or a non-action. Contracts are exciting like that. Define what the default is. Figure out what the defaults are, and now look and see if there has been one. If there's been a default and you're trying to get out of the residential sales contract, that default may excuse your contracts are performed, your performance under the contract, and allow you to terminate it depending on what that default is. If you can find a default, and it's tough, it depends on the facts. I don't know the facts. If you want me to look at it, you got to give me a call. So now we found whether or not there's a clear out first, your attorney modification. Now you've reviewed all the defaults. Third thing you're really going to need to look at, if you can find a default that may entitle you to exit the contract, you have to provide the notice of the default, and it has to conform with all the specificities of the contract. Where must that default be sent? How long do they have to cure? Oh, what's a cure? Now that we've provided notice of the default, it often triggers what they call a cure period. A cure period is a space of time. Let's say it's 10 days. It's often 10 days. Sometimes it's 14. It could be 30 days. I don't know if it could be 3 months. Contracts are flexible and you can really negotiate most every aspect of them. Often you have, like this, a standardized contract because these transactions will happen thousands of times. I would be darn sure that Cook County has a standard form residential real estate sales contract because there's millions of transactions, and you want them all to have similar hoops to jump through so that always the rules are the same. Otherwise, things can get really, really confusing, and boy. Now, third, you found the notice of default. You've complied with the notice of default sections. We're in the cure period. What happens at the end of the cure period? Maybe the mistake, maybe the default is not fixed, and that will allow you to get out of the contract by its termination. There might be specific provisions in the residential sales contract that provides for that. You have to review it with an attorney. Fourth, look for an attorney's fees provision in your residential sales contract. Have you hired an attorney already without even knowing it because you signed a contract to buy a piece of residential real estate? Very frequently, attorney's fees contracts are in real estate contracts. Sometimes they're two-way. What does that mean? It means that if this matter blows up and you have to go to court and you prevail in court, you will be entitled to your reasonable attorney's fees. And the shoe would be on the other foot in case you went to court and lost. The other side would be entitled to attorney's fees. That's the most egalitarian and fair version, but if the buyer has an attorney, but the seller doesn't have an attorney, maybe the buyer would try to sneak a fast one in that says that if the seller defaults, they aren't entitled to attorney's fees, but if the buyer defaults, they are. So check and see if you've already hired an attorney by signing that contract. Because what's going to happen? Well, if you try to terminate a contract and walk out of it, you might expose yourself to litigation risk for a specific performance lawsuit. As the buyer or seller, somebody's trying to get out of the contract because of a default that entitles them to get out of the contract. The other party might get mad and try to sue you for specific performance. And specific performance is a cause of action that makes the parties perform the contract. It's different than other types of contracts that don't involve real estate collateral because there's only that one and only 123 Fake Street in Chicago, Illinois. There's not two of them. It is unique. And because it's unique, the only remedy that you can really get is being awarded the purchase price for that house. You know, the amount of money damages doesn't suffice. You wanted that particular piece of real estate, and there's only that one, which is one of the elements of a specific performance action. We aren't going to go into that any further because that's more germane to the answering of the question, what can I do if somebody tries to get out of the contract? This one's about you getting out. The next one's about what happens if the other guy tries to get out. Moving on to the fifth contract provision that may let you get out. If you can't find anything in the main corpus of the contract, check all the amendments. Very frequently, houses are not first-time constructions. No, most houses have actually been there for a while. If it's a first-time construction, that's fine. You're probably not going to need a buyer's inspection because the house is new construction. There might be a different type of financing being provided by the bank as opposed to your plain vanilla residential mortgage. The bank follows a very specific procedure to issue that mortgage. And one of the things they're going to want to make sure is the amount financed is collateralized and secure enough. How do they do that? Well, they'll order an inspection of the real estate. Because if the purchase price is $100,000 and an appraisal and the market says it's worth about $100,000, but then you hire an inspection to go on and boom, we found a lot of problems. Maybe there's some termites infestation. Maybe there's issues in the electrical or in the plumbing or something that's going to cost an extra $10,000 to $15,000. You know, they aren't going to want to issue the loan against a piece of collateral that isn't worth $100,000. It's actually going to be worth $85,000 because of all the repairs that are necessary to make it habitable. Watch out for that. That is why a buyer's inspection amendment is very frequently checked, especially if the house is older. And if that buyer's inspection amendment issues as it's operating, you check that you want that amendment. an inspector goes out and they issue a report, and maybe there's some material structural damage. And that material structural damage then has to be fixed prior to the closing. That might provide some type of out to the buyer or the seller based on how much is required to fix the problems that an inspection finds. So those 5 things, let's sum them up. First, maybe there's a provision, an attorney review provision in your residential sales contract that entitles you to exit quickly. After that, you're going to need to review the entire thing for defaults. Third, you're going to have to make sure that you comply with all the notice requirements for those defaults. Fourth, look for an attorney's fees provision and see if you've hired an attorney or if you get the attorney's fees if you are successful. And fifth, review all the amendments to see if there are other rights that are out there beyond the main corpus of the residential sales contract. So there you have it. When you ask, can I get out of this residential real estate sales contract? Believe me, the facts might be there, but you're going to need to review the specifics of your contract. And the reasonable thing to do is walk through that with an attorney. So if you have any questions on how to get out, please feel free to give me a call, and I'll see you real soon with our next collateral base answering the question, what do I do if somebody tries to back out of a real estate sales contract? See you next time.